In today's video, we return to corporate practice of medicine, the prohibition there against, and talk about whether CPM or CPOM concerns ever really go away. Hi everyone, I'm Michael H. Cohen. I'm founding attorney of Cohen Healthcare Law Group. We help healthcare industry clients just like you navigate healthcare and FDA legal issues so you can grow, launch, scale your healthcare business. On our healthcare and FDA law blog, we talk extensively about corporate practice of medicine and how the MSO model helps healthcare ventures navigate the twin concerns of CPM and anti-kickback law. Simply put, the MSO, the management and marketing company, takes fair market value from the practice or clinicians under its branding umbrella in exchange for its services. Some states, like California, New York, and Texas, have very strict prohibitions against corporate practice of medicine. Some are looser. But what more is there to see? What more is there to say? Everyone would like to see the strict form of CPN go away, everyone in industry. Some healthcare companies pretend it doesn't exist. Everyone knows it's there and wants to comply without paying a heavy cost of compliance. Cannot bear that burden, okay? So what we normally do with our clients is we deploy a model that will work in the strictest state, yet not crush the business with red tape and regulation. The MSO model can work to give the healthcare venture profits without making it too dependent on the physicians and clinical care providers. For today, let's focus on how quirky states can be in their enforcement of CPM prohibition. Let's take this unusual judicial opinion, for example. The court examines a profit-sharing arrangement. Yeah, there's always profit sharing, but they call it a profit-sharing arrangement between an MSO and a professional corporation. And the court finds that the MSO has violated corporate practice of medicine. Boom. What happened here? The court first goes through state law and it finds that the state's common law generally prohibits the corporate practice of medical professions. But professional corporations composed of entirely professionals may be organized for the purpose of rendering professional services. Only licensed persons may own shares in a professional corporation. Okay, so far nothing new here. The prohibition applies, whether we're talking about medicine, psychology, optometry, dentistry, or another healthcare profession. Not all of them. It depends on the state, but let's just say a bunch of them. Now next, the court goes through and analyzes the business arrangement. And so here's the formula: patient revenues less MSO expenses. Not that uncommon, but the court finds that this is a partnership because the court said the MSO had the right to control the practice and engage in joint business decisions. Okay, like what? Well, the MSO controlled the bank accounts, the practice's finances, payroll, bookkeeping, insurance. Okay, not that big of a deal. Hiring and firing clinicians, not good. That's a black mark. The other ones are most likely administrative and management tasks. That should have been unobjectionable. But one thing is the MSO also restricted the ability of the main provider to practice outside for 2 years after termination of the MSO agreement. The non-compete arrangement demonstrated that the MSO wanted to protect its economic interest in the joint enterprise and prevent competition from eating into its profits. So moral of the story, the MSO model has eroded a lot of the old strict rules about corporate practice of medicine. It's a pretty good model, but MSOs can go too far, as in this case with a non-compete. And when they do, courts can find a CPM violation. Now in general, navigating between the letter of the law, how it gets interpreted, and how it gets enforced, and what industry actually does to remain competitive, this requires legal strategy. So don't be impressed by a starch white collar. This is no starch, I hope. That's what I asked for. A stiff gray suit, a firm handshake. I like firm handshakes. Mahogany tables, very nice. Glass enclosed conference room. But don't be seduced by the promise of freebies either. You need a lawyer that can do a high-powered dose of strategic thinking to help you navigate. Thanks for watching. Contact us with your questions. As always, we've helped so many healthcare industry clients just like you titrate between the law and compliance and what they actually want to do. And we'd love to work with you on your journey to success.